A news just coming in. President John Dramani Mahama has suspended the Chief Justice Gertrude Torkornoo following the determination of a prima facie case against her in the 3 petitions submitted to the president seeking her removal. We have details for you right now in relation as the president also sets up a 5-member committee to investigate the set details in the petition. I am here with my colleague Joseph Akable, but we'll be getting into the details as to this breaking news that's coming through right now, Joseph.
Well, big news coming out now. We know that this is something that a lot of people have been looking forward to. Questions have been asked. At what stage are we in terms of this particular process? We know that the petitions were sent to the president. We know that the matter is in court. An aspect of it is in court. All those are issues that we had discussions over. You recall the back and forth over whether the president can't proceed with a consultation despite the fact that there was a pending motion seeking injunction. That matter is back in court on May 6th. What we'll be doing at this point in time is to break down all of these matters to you, to let it make sense to you. But the main point being that the Chief Justice has been suspended by the president. And
perhaps we'll start off with that statement that's coming through from the quarters of the presidency this hour in relation to that suspension. Joseph, you have a copy of that. If you could just start off with a verbatim reading of really what the president is saying in this particular address to the nation.
So the statement is titled, President Mahama suspends Chief Justice after setting up committee to probe petitions. President John Dramani Mahama has, in accordance with Article 1466 of the Constitution and in consultation with the Council of State, determined that a prima facie case has been established in respect of 3 petitions against the Chief Justice, Her Ladyship, Justice Gertrude Araba Isaba Saki Torkornoo. The President has consequently established a committee in compliance with Article 1466 of the Constitution and in consultation with the Council of State with the following composition to inquire into the petitions which have been referred to them. So in terms of the membership of this particular committee, 1 is Justice Gabriel Scott Palmine, who is a Justice of the Supreme Court, who will be acting as chairperson of this committee. Justice Samuel Kwame Adibu Esiedu is also a Justice of the Supreme Court. Then there is Daniel Yao Domelevo, you all know him, a former Auditor General here in Ghana, and Major Flora Bazwanura Dalugu of the Ghana Armed Forces, and Professor James Sefa Jisa, an associate professor at the University of Ghana. So pursuant to Article 14610 of the Constitution, in accordance with the advice of the Council of State, the President has by a warrant suspended the Chief Justice with immediate effect pending the outcome of the committee's proceedings. And this statement is signed by Felix Kwatio Fosu, the spokesperson to the President and Minister in charge of Government Communications.
And we see a number of things immediately detailed in this statement that's come from the President. 1 having to do with the provisions on the processes in removing the Chief Justice. The President has exercised that right to suspend the Chief Justice pending investigations by this 5-member committee. Now we've seen the composition of the committee as well, and has been rightly articulated in the Constitution. 2 members from the Supreme Court, and then 3 others who are not lawyers as well and are not members of the Council of State, all rightfully listed. Per what we're seeing, the supposition is that Justice Gabriel Palmine will chair this particular committee, which will be looking into the matters in these 3 petitions which have gone before the president, and we now have a determination that there's a prima facie case that's been brought against it. I want to just, from the start, again, perhaps walk viewers through where we've come from up until this point, that a prima facie determination has come through from the president, and then we'll be crisscrossing different parts of the country as well, and then perhaps lean into the arguments that have been made to and fro as to really what happens from here on in. And so, viewers, stay with us as we try and start the entire process again from the 25th of March. That's where Felix Kwatio Fosu released that statement detailing that 3 petitions had been submitted to the president, and the president has forwarded same to the Council of State pending consultations with them for a determination as to whether or not a prima facie case can be brought against the Chief Justice, or whether or not she has a case to answer. The essence of that entire Latin word prima facie is whether or not the Chief Justice, per these 3 petitions, had a case to answer involving these 3 petitions. And from there, we know that suits were filed against the ongoing processes questioning whether or not the president had afforded the Chief Justice the opportunity to be heard. In fact, on that 27th, there were two suits we know which were filed in relation to this particular matter. And on that same day, we saw the Chief Justice writing to the president asking for copies of the petition, upon which she was expected to be given a right of fair hearing, an argument she made quite succinctly in that write-up to the president. On the following day, the 28th, the president wrote back to the Chief Justice, including the three petitions, while expressing disappointment. Is worthy of note that the letter from the Chief Justice on the 27th had leaked to the media even before it got to his quarters, but nonetheless wrote back to her and gave her 10 days upon which she was supposed to respond to these three petitions. And then we know as well that while the Chief Justice was writing to the president in relation to her official responses, the suits which were seeking to injunct the entire process were also expected to be tabled before the Supreme Court. On the first day where the injunction applications were expected to be heard, on the 9th of April, the suits were not heard because the Attorney General had written to the Supreme Court asking that they be granted some leave because there was a seminar of some sort which was happening between state attorneys. Godfred Dame Joseph,
yeah,
you
he expressed serious concerns. He expressed serious concerns about the fact that he does not understand why such a matter that is being dealt with of this nature, especially because he says there's a deputy attorney general who he makes the argument it's not a state attorney. So one of them could have been dispatched to handle that particular case. And you recall again that it was at that engagement that I had with him that he had made a point that as far as he's concerned, he thinks that the president cannot proceed with a consultation with the Council of State
the pending suits.
Because of the pending suits that are outstanding. Until those ones are dealt with, as far as he was concerned, the case has to be on hold. The consultations have to be suspended for the matter to be dealt with.
But that did not stop the Chief Justice, we understand, in subsequent days in submitting her official response to the president as well. And so after that happened, we proceeded to the 16th, which was the next agenda date for that particular suit, seeking to injunct the ongoing process which has reached this particular stage where a committee, a 5-member committee, has been formed. On that day as well, we know that they could not sit because a justice expected to be on the panel was not present.
In fact, it was the same day that we heard for the first time from the Attorney General speaking directly to this process. Now, the Attorney General takes a different view to what Godfred Yabuadami had taken. Dr. Dominic Aine told us that as far as he's concerned, the president's role, interaction with the Council of State in terms of determining whether on face value there's a case that a committee ought to be set up to look into, is a constitutional duty.
Right.
And he says nothing enables any court to interfere with the president exercising that constitutional duty. And so when we asked him directly what he makes of the position that had been advanced by Godfred Dame, he made the point that as far as he's concerned, nothing stops the president from undertaking that consultation. We know that they are supposed to go back to court on May 6th, but we know that the president has gone ahead to exercise the constitutional duty. As his Attorney General had indicated, he was not going to be stopped by any court, or no law allows any court to stop him from doing so, which is exactly what the president has done today.
And you're raising already the first of many questions which Ghanaians are going to be asking. What happens to that May 6th sitting where the injunction application was supposed to be heard, and whether or not the court was going to be able to injunct what the Attorney General described as a constitutionally mandated process which required the president to go through. Let's try right now and get responses quickly from Martin Pebu, who's a private legal practitioner, on the latest that we're getting from the quarters of the president. Counsel, appreciate that you could speak to us this afternoon. The latest coming from the quarters of the president, first ever, we're having a Chief Justice suspended pending a determination of this 5-member committee, whether or not she will stay in office. Are you surprised by how all of this has played out up until this point?
I'll say yes and no. Surprised to a certain extent, but also not surprised. So let's say the truth of the matter is that as soon as some of the information surrounding this case leaked on social media, and looking at that, then it began to show that, hey, something like this could happen today, because some of the rules are a bit strict. I don't want to go into the specifics because the committee is now going to go into the matter. But what the point I'm making is that we all have seen certain things on social media, and some of those rules are strict. You see, the painful side of it is that, yes, the figures may be small, but it's the same rule. You know how in Ghana, and I'm not prejudging, I've not mentioned what I've seen, but I'm just giving an example. You know how we talk about when somebody steals a goat, he gets convicted quickly, blah, blah, blah. So the point I'm making is that, yes, it's true that some of the things we've seen on social media, they may look like they look small, the figures look small, etc. But unfortunately, it's the same rule, whether the thing is 1 Ghana cedis or 200 million Ghana cedis. So based on certain things that I saw on social media, the surprise element went away because the way those things were looking around, though, and thankfully, look, and to be very clear, it's not a petition I've seen. I've not seen any of the petitions, but we saw this excerpts of some audit reports, etc. And when you see sections, you look at the language, you try to look at the grammar, syntax, all those things, context, to find out whether this looks genuine or it's fake. And some of them looked genuine. And since then, it's not been rebutted. And even the MPP also, I left out the main point. The MPP in their press conference also gave some information that showed that they had seen some of these things. So when you put everything together, actually the surprise element, it's been gone for some days now.
Let's talk about the integrity of the process, part of which you've been speaking to about portions of these petitions and the conversations which have surrounded it up until this point. Would you say that based on what it is we've seen up until this point, the integrity of this entire process up until this determination by the Council of State in consultation, or the President in consultation with the Council of State in determining there's a prima facie case, that process has been safeguarded, would you say?
Absolutely, Martin. Absolutely. Look, listen, I want to say something that 10 years from today, I will be able to say the same thing. I think so far the process, the integrity has been safeguarded. You remember, I mentioned that what we saw, at least from what I saw, and which is going around on this in social media, is an excerpt, or let's say excerpts of audit reports, not a part of the petition. I'm telling you for a fact that I haven't cited the petition.
Right.
And looking at, yes, so meaning that it's been safeguarded, because if a lawyer, at least somebody like me, interested in public interest, etc., the petition hasn't leaked to me, it tells you that the process is been safeguarded. It's been safeguarded.
Right.
So all I'm saying is that based on the report, that those excerpts, and then based on what the MPP revealed at their press conference, where they sought to cast insinuation and already saying the next Chief Justice will be a party sympathizer of the MPP, those unsavory things, that is what took away the element of surprise for me.
There are a number of questions that spring up off the top of my head in relation to the process now that we're getting into this 5-member committee. Even before a determination of a prima facie case could have been made, there was this heated debate as to whether or not the Chief Justice had a right to be heard in determining whether or not a prima facie case has been formed or has come up against her. She's provided her response. There are many who ask the question, wherein lies the rest of the process, where she's already provided her written responses to these allegations, and yet a determination has been made that there's a case for her to answer. Wherein lies the fact that she can't come out of this hole?
Yeah, so Martin, it's the nature of the process. That's the design. That's the way it's been designed. That, you see, let's repeat. The prima facie doesn't mean she's liable. It doesn't mean she's liable, or less in this context, for effective communication. Let's borrow the word guilty from criminal law. We are speaking ordinary English, so I'm not tied down by strict legal rules. So it doesn't mean she's guilty, but it's not a criminal case, but we can use the word guilty. It doesn't mean she's guilty. It just means that the allegations seem to be, if she doesn't give a proper answer, it can go against her. That's the meaning. In other words, the allegations are not frivolous. They've not been made up, but rather there are certain things that exist. And so now we need to go in further, because remember that you see, the allegations are on paper. She gave her response on paper. Okay, paper to paper. Now we need to go before the committee. You come and swear before the committee. You see, it's going to be examination. You see, they are going to do an inquiry. Even though we know people can lie on oath, etc., but they are going to a court proper. All I'm trying to say, one word is that come and repeat these things on oath. Look at your Bible and come and repeat these things. Look at you, come and take your Quran and repeat these things. You're a traditional worshiper. Okay, come and affirm and tell us that these things are true. So it's when you come and swear and say they are true. You, for now, let's leave out the fact that people can lie. Yeah, let's leave that out for now. There is still that solemnity that if you can hold your Bible, promise that you say the truth and say it, then it gives it greater weight. Then they will ask you questions. So we want to solemnize the things. We want to come and repeat them on oath. Then they become weighty. You know how Ghanaians don't joke with our religion.
Right.
As to how we practice, it's a question for another day. So when we do that and the answers remain the same, nothing changes, then it can go against her. That, okay, then you are guilty.
Right, Counsel, Mawena here, and I just want to ask one question before I bring in my colleague Joseph as well, who's here with me. That's in relation to the ongoing court processes, the injunction application, which had been adjourned to May 6th, and then the entirety of the application, which was seeking to have the Supreme Court now finally proclaim a direct way through which this entire process of the removal of the Chief Justice can go through. What happens first off to the injunction application now that we've seen the president reach this determination, and then the substantive case as well?
It means effectively the injunction application becomes smooth. I mean, I'm speaking practically. You see, I don't want to do legal. If we do too much legal, we will lose the public. Practically, once the president has gone ahead with the committee, now the Supreme Court will be slow from their own decisions in the past. Let's all remember the E-Levy one. E-Levy, even when, Oliver Bakavoma filed for contempt, the case was pending before the court, yet GRA and Akufo-Addo went ahead and started collecting the E-Levy where they promised millions of jobs. That never turned out to be true anyway. They went ahead. There are countless other cases that we can show. So what happens is that there is a rule. So in law, you hear, to every rule, there is an exception. To every rule, there is an exception.
Right.
So generally, when it comes to the performance of public functions like this, then the court is slow to grant an injunction to stop the performance of a public function. The committee that has been set up, they are going to perform a public function. The work that the President and the Council of State have done, they are public functions. They are in Article 146 of the Constitution. So the courts are slow to do that. And you see, this same thing we are talking about, don't also forget, the law works in a certain context. Look, trust me, another petition, let's say, go into our future, a petition can happen tomorrow, and based on the public reaction, a president can stop. So let's know that sometimes it's not pure law, but it's also an amalgam, a totality of our reactions as citizens. The thing, if enough citizens had gotten up and started demonstrating that, President Mahama, please stop, let's finish the court case, yes, it would have happened. But once you don't have enough, because remember, and there's basis for it.
Right.
Because under Article 125 of our Constitution, it says that justice emanates from the people. So at every point in time, when the president is acting, and even the judges, etc., they also look at what the people think. So if the country was up in arms, saying that, no, President Mahama, please wait, he would have waited. Right. I'm telling you, enough numbers. So it's not strict. Sometimes it depends on the reaction of society as well.
Right. Counsel, Blake comes in here right now, Joseph.
Yeah, Marina, thanks. And sorry for calling you Martin.
Sure. But Council, just hold for us. Let's try and just get viewers to understand, those who are joining us right now, what the breaking news is. And that breaking news is that President John Dramani Mahama has suspended the Chief Justice Gertrude Torkornoo and subsequently formed a 5-member committee which is to investigate her for 3 petitions seeking her removal after the Council of State, along with the President, determined that there was indeed cases for her to answer in relation to these 3 petitions. We're going to run you through the membership of that 5-member committee again, and then we'll go back to Council for a bit more in relation to what it is that we're seeing. And so that's what's on your screen right now, the 5-member committee, which has been set or formed by the President, Justice Gabriel Scott Poaman, who is the chairman of the committee. Also, Justice Samuel Kwabena Dibu Esiedu is a member. Daniel Yao Domelevo is a former Auditor General. The first 2 are justices of the Supreme Court. Then there is Major Flora Bazwanura Dalugu. Is an ordinary Ghanaian or a member of the Ghana Armed Forces. Remember that the provision of Article 146, amongst many other things, says that they must not be lawyers or members of the Council of State, amongst many other things. And then Professor James Sefa Jisa is an associate professor at the University of Ghana. Joseph, you want to just talk to us about these members as well, these 5 that we're seeing?
I mean, Justice Gabriel Scott Poaman is the 2nd most senior Supreme Court judge. In terms of the current composition of the court, it's only Justice Paul Bafubon, who was appointed to the Supreme Court in 2008, who is senior to him. He joined the Supreme Court in 2015. He joined under controversial circumstances because with the appointment itself, there was a whole court case that was initiated by the Ghana Bar Association. They had raised questions about issues relating to whether why the president is allowed to appoint in accordance with the recommendation that comes from the Judicial Council, the list. When they do 1 to 10, can he pick around any part of the list, or is required to start in accordance with the list? He has to start from 1. If he's picking 5, he picks 1 to 5.
Right.
And so that is how come he was one of the 2 judges who were appointed at the time. The other was Justice Yawape, who has long retired. And so Justice Gabriel Poaman is still at the Supreme Court. He has gone on to deliver very interesting decisions over the period. Some of the decisions that have extended the frontiers in terms of the legal dispensation.
Right.
One that really comes to mind is the case of the ex-party's Senate case, a Republic versus the former Senate boss, the Director General, who was being prosecuted for the OBS software system. In that judgment, he discusses extensively issues surrounding administrative justice, judicial review. If you're asking a court to take a second look at the decision of an administrative body, what standards do you have to meet? It's one decision that, interestingly, the Chief Justice, who has been suspended, wrote the lead opinion. Justice Gabriel Poaman, who was on the panel as well, wrote the concurring opinion, and he discusses extensively judicial review in the Ghanaian context and how he thinks is different from the common law provision. Justice Samuel Kwame Adibu Esiedu is also another senior Supreme Court judge as well. He was appointed to the Supreme Court by President Akufo-Addo. When he was at the Court for Appeal, he was also sitting as an additional High Court judge, and he was handling the trial involving the former NDC chairman, Samuel Ofosu-Ampofo. He was the one handling that case before we know that case was terminated eventually by the Attorney General. So that was also one matter that he did. Interestingly, and it's one of the questions that I'll be putting to Council when we get back to him. Justice Samuel Kwame Adibu Esiedu is on the panel hearing the injunction case in the Vincent Assefuah matter. The injunction against the process. He's participating in that particular proceedings. In terms of his judgments, he also has given some very interesting judgments at the court. One of them has to do with the issue surrounding if a law is repealed and you are being prosecuted, what happens? Can the trial go on or not? For those who are familiar with the law, Edmonado versus Attorney General is the case that he wrote the lead opinion on. Very interesting decision in there. So he's a very senior Supreme Court judge at the Supreme Court who is also participating in this one. I'll end with Daniel Yao Domelevo, the former Auditor General. You know him, most recently he was part of the Operation Recover All Loot team, a team that Council on the Line was also a member of that particular team. We know that he was Auditor General. He was one of the individuals who was appointed just before John Mahama exited office in his first term, together with the Shrag boss Joseph Whittal. When he was appointed, we know that in the course of his work, he was asked to proceed on leave, and effectively by the time he came back, in fact, he never came back. He eventually ended up retiring.
Yeah, someone else had.
The matter ended up at the Supreme Court in the case of the CDD versus the Attorney General. And the Supreme Court took the view that the president asking him to proceed on leave and a subsequent removal from office was unconstitutional. And so that is how he left office as the Auditor General. But he's one, we know him as an anti-corruption crusader quite closely. And counsel made reference to an aspect of this particular matter that has come up. The screenshot that we see in the public domain, we don't know whether it's in the petition or not.
Having to do with audit-related matters.
Audit-related matters. And so that is another thing that has come up.
Perhaps why there could be a decision to lean in on him when there are audit-related matters in these alleged screenshots that we've seen, none of which we can substantiate. Yes.
But it's consistent with the constitutional provision in that the majority for this particular committee relative to the Chief Justice, they are not supposed to be lawyers or members of Parliament. They are not supposed to form. If you compare to the other justices of the Superior Court, the 3 are from the legal fraternity. So this time around is the 3 from the other individuals. Right. And the question first I want to put to counsel, and you did indicate that we want to make things very simple for the ordinary Ghanaian. They will ask, who is the Chief Justice of Ghana as we speak? The statement is silent on that, but we know that in terms of the convention, if the Chief Justice is not around, the senior most judge acts in his stead. In this case, Justice Paul Bafo-Boni. Is it your understanding that with the statement being silent on that, he, as of now, should be the acting Chief Justice?
Absolutely, Akabli. Absolutely. There's a specific provision for it in the Constitution. It's in there. I don't really have it here, but it's patently written that in the absence of the Chief Justice, the most senior Justice of the Supreme Court takes over. So it means that effectively, Justice Paul Bafo-Boni is acting Chief Justice. There can be no two ways about that.
I mean, the second question to you, counsel, has to do with the case that is ongoing in court. Justice Kwame Adibu-Esiedu, who is on that particular panel, the injunction aspect of it, he is to form a part of this particular committee. I mean, if you were a party in the case, would you be comfortable with him remaining on the panel, or you think that ordinarily there should be some steps, maybe he himself recusing himself from it, given that they are being asked to determine first whether the person should have been restrained? That's now he's made a point that he's moot. Then the substantive issues of whether a fair hearing should be given before the prima facie determination is taking place. He's participating in that particular case.
Okay, so looking at it, it's possible maybe my answer will change. But for now, on the face of it, what we usually use to determine is whether he sat on the case. Yes, so you can be empaneled. But if you haven't had the opportunity to attend the hearing, generally, in our Ghanaian context, people will not raise our eyebrows. But from what you are saying, I get you. But, you know, sometimes this is Ghana, that's I mean, it's the state of our thinking. You see, in every society, it's not everything we're able to copy exactly from the white man. Ours, because everybody knows somebody, and you will find that even in Supreme Court decisions, you see the Salah case, etc.
Right.
When it comes to recusal, we are a bit different. So the main thing the average lawyer will tell you is that he didn't sit on the case. He didn't like come into open court and the case called and he had arguments. You see, but right. It doesn't mean that you don't have a point.
Counsel, hold on for us briefly. We've been joined by the Minister for Government Communications, Felix Kwatso-Fosu, on the telephone lines right now. He authored that statement, which has become the subject of conversation. Many thanks for joining us this afternoon. How soon did the President, in consultation with the Council of State, reach this determination that a prima facie case can or has been found against the Chief Justice? Hello, Mr. Kwatso-Fosu, can you hear us? Hello, Felix. Well, it does appear we don't have him. But Counsel was making the point about the recusals and how not so frequent of a development it is in this part of the country.
In fact, generally the conversation centers around issues of suspicion of bias and the real likelihood of bias, which was the point he was making, that Ghana generally we tilt towards the real likelihood of bias, and the courts have over the period. In fact, we saw it happen in some of the cases. The most recent one had to do with the case relative to the declaration of some seats in Parliament as vacant.
Right.
When the matter went to court, you know that lawyers for the Speaker of Parliament did raise issues about 2 of the judges that they wanted recused. I mean, the court quickly went on recess, came back and took the view that once the judges have been appropriately appointed in accordance with the Constitution, it is presumed that they can act in a fair manner.
Right, let's go back on the telephone lines with Felix Kwachofuso. Mr. Kwachofuso, many thanks for speaking to us. Curious on the minds of a lot of Ghanaians, when the president, in consultation with the Council of State, reached this decision that the Chief Justice had a case to answer based on these 3 petitions.
Please speak up. I can barely hear you.
I'm asking when, between Thursday and today, when the president, in consultation with the Council of State, reached the conclusion that indeed the Chief Justice had a case to answer?
Well, I'm not able to disclose details of the process. As you yourself may know, there are strict rules of confidentiality. But I can tell you that such a conclusion has been reached, and it is on the basis of that the president has taken the step that I have just announced.
And so, amongst many other things, one question that's being asked is, this statement you issued is silent on who takes over now that the president has suspended the Chief Justice. What's the expectation of the president?
Well, the judiciary is a well-established institution in our country. They have their own administrative processes for getting someone to act in the stead of the Chief Justice in the event that she is temporarily unavailable. That is not a matter that the president determines. It is for the judiciary to make their own arrangements.
First ever of such a decision we've seen happen under any republic outside of the first ever president the country had when he removed the Chief Justice. What sort of processes went through this arrival at this decision? Because many are curious as to why we're seeing this happen for the first time and under John Mahama.
Well, the processes are clearly outlined in Article 146 of the 1992 Constitution. Indeed, you only have to read the statement I put out to appreciate the steps that have been taken. You recall that some weeks back, I informed the nation on behalf of the president that he has received petitions from 3 different courts alleging various forms of wrongdoing against the Chief Justice and demanding her removal from office. Upon receipt of that, and in strict conformity with the dictates of the Constitution, President Mahama began a consultation process with the Council of State, which consultation process required that he, in consultation with the Council of State, determine whether there was any basis to proceed, i.e., determine whether there was prima facie warranting any further steps as prescribed by the Constitution. So you recall that he forwarded the petition to the Chief Justice in consultation with the Council of State and requested her to provide responses in order to enable an assessment as to whether or not some prima facie exists on the face of the petition. This was complied with by the Chief Justice, and the President continued the consultation process with the Council of State. And the outcome of that consultation was that prima facie has been determined in respect of all 3 petitions. This also then means that Article 146 of the Constitution must kick in, which then requires the President, in consultation once again with the Council of State, to set up a 5-member committee whose composition is contained in the statement I just issued. That membership of the committee is such that 2 of the members must be justices of the Supreme Court,
right?
One of whom will chair the committee, and 3 other individuals who are neither lawyers nor members of the Council of State. And so you find that the 3 others who have been named meet this criteria. They are not lawyers, they are also not members of the Council of State. Once that is done, the petitions will then have to be referred to the committee to inquire into as to whether or not there is a basis to remove the Chief Justice from office. Now, while the committee does its work and once it has been set up, Article 146(10) of the Constitution empowers the President to suspend the Chief Justice for the duration of the work of the committee up until such time that they make recommendations to the president on what further step to take. So you find that everything the president has done has been grounded in the Constitution, Article 146, and its various provisions. So if you ask me about the process, this is exactly what has transpired since the tendency of these petitions.
All well and good, these processes you've outlined, but one criticism which is coming strongly from the quarters of the opposition NPP is that you're abusing these laid down processes in Article 146, and what we've seen happen up until this point is an attack on the country's judiciary.
Well, first of all, the NPP itself has come in for criticism for their unwarranted politicization of this particular issue. It is curious that it is a political party, the New Patriotic Party, that appears to be up in arms about this. Otherwise, every reasonable person understands exactly what is happening. That the president is required to act in specific ways once he received this petition. In fact, before President Mahama took office, in the dying embers of the Akufo-Addo administration, a similar petition went to the president, and he took the same steps that the president has taken, except, of course, the determination of a prima facie. President Akufo-Addo also went into some consultation with the Council of State to determine whether there was prima facie in that petition. He, on that occasion, said there was no basis to proceed further. President Mahama, on this occasion, believes that in consultation with the Council of State, prima facie has been determined. So it is not clear why the NPP believes that when they are in power, their president can act in accordance with the Constitution. But when they leave power, another party that comes to power cannot act in accordance with the Constitution. So one has to question the sincerity that they bring to this whole discourse and question whether or not it is not politically motivated. Because quite frankly, they have not covered themselves in glory in this particular matter. They have needlessly politicized this and created an impression that the Chief Justice is one of them and she's been handed. And it is manifestly unfair to the Chief Justice what the MPP is doing. Their claims also do not hold merit because they cannot point to a single infraction on the part of the President in this whole process. And I'm not sure why they continue on the tangent that they are going. What has simply happened, and I must stress, that the President has not said that the Chief Justice is guilty of any offense. The President has only said that when he consulted with the Council of State and looked into the petitions and weighed them against the Chief Justice's responses, it became clear that there are further questions that need some answers. The platform to do that is spelled out clearly by the Constitution, and the President has followed that particular stipulation to ensure that the matter is determined conclusively, that it is determined by persons who are clothed with the mandate to do so, which is the committee that he has set up. So, again, I must express my surprise about the conduct of the New Patriotic Party in this instance. One can only infer political motives to what they are doing.
Just final question from me in relation to this 5 members we're seeing, senior most, second most, senior most at the Supreme Court, and then the membership. We see a security person, we see an auditor, a former auditor general as well, and then a person from academia. Is this leaning into the details captured in these petitions, which is forcing the president to toe the line in the individuals, the non-members from the Supreme Court, which were seen on this 5-member committee?
Well, the rules governing this process are pretty strict and stringent. One is not permitted to make any disclosures in respect of the details of the petitions. It is only the President, the Council of State, the petitioners themselves, the Chief Justice, who natural justice demands is giving copies of the petitions, and the committee that has been set up who are seized with the petitions. No one else has a right or authority the details of this petition. So, regrettably, I'm unable to answer your question as to whether or not it is the nature of the petition that has necessitated the selection of the individuals who have been selected. Right. That if I were to go into the mind of the president, I believe that he thinks that these are the individuals who have what it takes to unravel the facts surrounding this petition, whether or not there is even any basis to remove the Chief Justice.
Then Felix, I appreciate that you could join us this afternoon. We'll leave the conversation. I'm sure we'll come back to you as and when it does require. So that's Felix Kwachofosu. He is the Minister for Government Communications. And the breaking news we continue to remind you of is that President John Dramani Mahama has suspended the Chief Justice Gertrude Torkornoo, pending the determination of whether or not 3 petitions brought against her, of which a prima facie case has been determined, will lead to her removal from office permanently. Remember, that 5-member committee's verdict on whatever transpires all through this investigative period, which has no clearly defined time limit, will be binding on the president. But Joseph, you were having a conversation with counsel just quickly.
Yes, I mean a question about the outcome of this committee's work and its impact. And counsel, I want to take you to Article 1469 of the 1992 Constitution, and it says the president shall in each case act in accordance with the recommendations of the committee. To the ordinary man, shall is shall. In law, sometimes shall is may and sometimes shall is shall. What's your own understanding of this particular provision?
To be clear, shall is shall, meaning that in this case, it is mandatory, all right? It is mandatory. The president would have no discretion in the matter, meaning that if the committee says the Chief Justice is not liable, or in other words, not guilty, the president is bound to go by it. Vice versa, if they were to say she's liable or let's say guilty, the president must go by it and so remove her. Okay, so and you know, in 2015, we had an example, Vivian Loretta Lamte. You remember the Shraj boss? Yes, she was taken through the same process. You remember an MPP member, Frank Anodompre, petitioned for a removal. It wasn't that petition that was, was used, but the one by Richard Nyama, also affiliated to the MPP, right? Yet, the process went on. The Justice Benning Committee went into it. And when they came out, their verdict was that she be removed because the grounds for her removal had been established. So President Mahama had no option but to remove Loretta Vivian Lamte. So that's what happened. So similarly, in this case, the recommendations of the the committee is what the president would go by. Yes, because you see that it's a committee that's going to go into the matter. They are the people going to hear the evidence on oath. As I've said, for now, let's leave out the fact that people can lie on oath, etc. The oath is no longer as solemn as it used to be in those days, but still, it's the oath. So they are going to hear these matters on oath, and they are even going to hear cross-examination. You see, sometimes you see something like A, but when the cross-examination comes in, that's when you see different shades of gray. So it's because it's a committee that will be seized with all of this, hearing all the evidence, etc. You see that at the end of it, they will be in a better position than the president to make a recommendation as to what should happen. So the Constitution has given them the greater weight that their recommendations are what the president should go with.
And Council, I want to end with 14611 because that provision states that the president may at any time revoke a suspension under this article. So it means that in between now and when the committee is having its proceedings, the Chief Justice could potentially be back in office if the president decides to do so. You agree with that as well?
Yes, theoretically, sure. Theoretically, it's correct, but let's also watch the practical side. You see, suspension of a Chief Justice is not a light matter. And you know me, we've been making noise all these years that in the new Constitution, the president should not be the one to appoint Supreme Court justices. And for that matter, all Superior Court justices, etc. One separation of powers, a better form of separation of powers, etc. So I know that the president did not take this decision lightly. So such a decision is not the type that you easily find it being reversed. No, because I'm sure they would have looked at everything. And don't forget, you even have our beloved Sofia Kufu on the Council of State, etc. So yes, theoretically it's correct that it can be revoked, but looking at what a quick revocation does to our judicial system and the integrity of the whole process, to be honest, practically, it's not something that will be lightly done.
We'll leave it here for now, Council, and we'll come back subsequently as and when there are more developments with regards to this particular story. And so that is Martin Kpebu. He's a legal practitioner, rights advocate. We've been engaging on this particular breaking news that is just coming in. And if you are just joining, the breaking news is that the president has suspended the Chief Justice. As you may be aware, there are 3 petitions seeking her removal from office. And the very latest on it is that the president has come to the conclusion in consultation with the Council of State that the 3 petitions disclose a matter that is worth looking into. And Marina, there's a lot of history that has been made because this is the very first time that we are getting to this level. And we go through the history, you see that there have been attempts in the past. In some instances, there were no attempts. But the point is that none has even gotten to the level that this particular one has gotten to.
Absolutely. And when I was speaking to Council and then Felix as well, the only stated record of a Chief Justice ever removed is during the tenure of Ghana's first president, Osajifo Dr. Kwame Nkrumah. Since then, either there have been attempts or there have been no attempts, but as to it reaching this stage, like you mentioned, none like that. Let's try and walk you through, and then we'll go to the presidency right now and gauge the mood from there as well. Since the Fourth Republic, which is the longest serving republic which we've enjoyed from a number of justices from the Supreme Court, started with Philip Edward Archer, sat through from 1991 to 95. There's no record really of him really having to have a petition brought against him. Same for Isaac Kobna-Aban, who was the Chief Justice from 95 up until 2001.
I mean, in terms of Justice Aban, there was not a petition directly, but there was a matter that went to the Supreme Court because the Ghana Bar Association had taken the view that he had conducted himself in a manner that they believe rendered him incompetent to occupy the position. So this was when he was appointed. But the Supreme Court came to the conclusion that what they were trying to do looked like an Article 146 procedure. And so the court dealt with that aspect of it. But in terms of a petition for his removal, there's no record of that.
Let's proceed. Edward Kwame Redu, 2001 to 2023, he received one petition. That petitioner was Francis Janku Asasi Kofi. The basis of the petition, he lied under oath about his date of birth, whether or not he was born in 1934 or 1932, became a subject of quite interesting debate. Also, this became the basis of this, where he lied before the Public Accounts Committee when he was going through the process to become
the appointments committee,
the vetting process, and then again committing perjury by providing false information to a public officer. A determination was reached on that petition so that it failed. It did not reach this particular stage, and then he, as and when, voluntarily retired as well. From him, George Kingsley Aqua, 2003 to 2007, the petitioner was Bright Oblite Akwete. The basis of the petition, judicial interference, where he alleged, amongst many other things, that he was instructing judges on how to rule on specific cases. There was a claim of abuse of office, misusing his authority in judicial matters, and then the victimization of judges as well. You have a few to say in relation to these claims? Yes, I mean,
just like the other ones as well. I mean, these allegations were very serious in nature that were made and leveled against the Chief Justice. But just like the previous one, this also did not succeed. It did not even get to the level where we have gotten to now at this point in time. And so that is the reason why we are constantly making the point that this is a very first time that we've gotten to this particular point in time.
Georgina Theodore Wood served for 10 years as Chief Justice. She had two petitions, one from the citizens of La Home and abroad, and their concern was quite straightforward, that she was unfairly handling land cases relating to the Gadangme people, and amongst many other things, they had an issue with that. Then there was another one from Ernest Obri Latte, which was on stated misbehavior and incompetence. We'll get the details as to what really the conclusion was, because that failed. But let's try and take you to the presidency right now, where Komla Kluche is our presidential affairs correspondent. He's at the presidency for us right now. Komla, talk to us what the feeling is like at the seat of government where this very crucial decision has been taken, the suspension of the Chief Justice, the first of its kind in our history as a country.
Well, I can say to you that there's very little talk about it at the seat of government. Mostly today has actually been a busy day for His Excellency the President. His first official assignment since assuming office as the head of state with respect to the 50-year anniversary launch of the ECOWAS. And so the President has not been in office directly, but he's currently holding a luncheon for most of the dignitaries or the heads of state who came to partake in that anniversary launch. But I mean, if you walk through the corridors, you could hear people, and most of them are tuning to TV3 and are monitoring the situation. But the talk amongst them is to the effect that this has been long overdue, has been expected, but my inquiry, especially at the top echelons of this administration, also revealed that the processes have been very fair to the Chief Justice. And I'm just going to take you back to that famous 28th March letter, where when the President received the petition, he directed his secretary, Dr. Callistos, to write to the Chief Justice, giving audience to her to respond to the issues. Now, this was a letter dated, like I did say, on the 28th of March, 2025, addressed to the Honorable Chief Justice of the Republic, and it's captioned petition for removal for the Honorable Chief Justice under Article 146, Clause 6 of the 1992 Constitution. And His Excellency has received 3 petitions from 3 individuals requesting your removal as Chief Justice. 2 are dated 14 February and the 3rd, 17th March 2025. Copies of the 3 petitions are attached. Now, you will recall that the Secretary to the President gave the Chief Justice a time to be able, I think about 10 days, to be able to respond, within which the Chief Justice, we understand, with record time, did send her responses. But on the issue, on the issue of the determination of a prima facie case, our sources within the presidency tells us that as far back as the early part of last week, the Council of State determined a prima facie case against the Chief Justice, but they only needed to exhaust the processes that should lead to where we are now. And the letter that is already out now, which was issued by the government's spokesperson or the communications spokesperson for the President, that does indicate that all the processes at all material time, they've been very fair to the Chief Justice. Even as we speak now, a committee which has been established is to go into the matter again, and she's supposed to be on suspension. This is not the final determination of the matter, but the processes they have indicated would be step by step, and you need to be very fair to her, and it must be in accordance with law. And this is what I understand from the top echelons, that this is what they are doing. They are not going to be fair. Many readings have been done into this. Many people say that they are out looking for the Chief Justice, but my understanding is that no, that is not the case. The petitions have been brought, but they have equally given the chance to the Chief Justice to respond. That's not the end of it. However, there's a need for them to go to the next step. And what now is becoming the talk of the day also, just like indicated early on, is who takes over from the Chief Justice. Who will it be? There are talks about Justice Bafo-Boni amongst the corridors, but well, just like the spokesperson of the government is saying, that it is up to the judiciary,
to make that determination
on the processes that they have to do, though.
Right then, Komla, thank you very much for those details. That's Komla Kluche, is our presidential affairs correspondent, coming through with us from what the 4 walls, or what the communication, really, the conversation in the 4 walls at the presidency is right now, Joseph. And they believe at the presidency, amongst what Komla has been telling us, this long overdue, the sentiment has been one that's been there, despite it being rubbished by the Minister for Government Communications, that, look, these allegations coming from the NPP that deliberates, seeking to impugn the integrity of the judicial system, amongst many other things, in the removal process of the Chief Justice. They've been fair, it all through this Article 146 procedure, and they believe that if indeed she will be exonerated, that will happen before this 5-member committee, which has been set up.
In fact, a key aspect of the entire process is the issues around the fact that the process has to be in camera. It should not take place in the public domain. And you recall the letter that Komla makes reference to, the president expressed concerns about the fact that the Chief Justice had written to him to ask for an extension. And even before he could review the letter and come to any conclusion, the letter was in the public domain. Right. And so in writing, he said that they were deciding to mark each of the pages as confidential, hoping that the sanctity of the process will be protected, because in the Supreme Court has previously determined on this particular matter, right, the Tiger Eye and Nas Justice Derry matter. The Supreme Court said that, look, if the contents were to go out there, the only available option would be that a person affected could seek legal redress by way of defamation against the person who publishes it. Because the point had been made that because the thing had been published, it should halt the process. But the Supreme Court disagreed with that particular one. So it is how important they are protecting the 146 process, which Komla makes reference to that letter. But the history that you were taking us through, Marina.
Back to it. After
2017 to 2019?
Yes, after Georgina Woods, there was Sophia Kufu, who happens to be a member of the Council of State right now, a former Chief Justice, and one of the legal brains, many believe, will be behind the determination of whether or not indeed the current Chief Justice has a case to answer. She had a petition brought up against her as well by Mensa Thompson of ASEPA. That petition failed to see the light of day. Then there was the man who followed him, Kwesi Enin Yabua, again, Mensa Thompson, and this had to do with some alleged 5 million bribe by one lawyer, a lawyer who you know very well, and subsequently who was referred to the
Akwesi Afrifa. He appeared before the General Legal Council, a case that had been handled. He had made the allegation that some 5 million had been paid. Minister Thompson of ASEPA latched onto that allegation and put it in the various processes and sent it to the presidency. It went all the way. The president consulted the Council of State and determined that no prima facie case has been made. And so it got closer to this stage, but it failed at a level that the prima facie determination was not made. And
then Gertrude Araba Isaba Saki Torkornoo, the woman at the center of what the conversation we're having today. 4 petitions, that's
because of the three,
but there was one
that did not go through.
Just in the dying embers of President Akufo-Addo's tenure, which is what we have here. Professor Stephen Kwekwasari, the basis of that petition, overstepping constitutional powers and appointing justices to the Supreme Court, which was a subject matter, that letter which leaked where she had written to the president proposing some names to be appointed.
5 judges, actually. She had made a point about the fact that they needed more hands on the court. And Professor Asari took issues with that to say that, look, under the process, the Judicial Council, which you chair, they are supposed to recommend to the president, and that you were signing the letter as Chief Justice and raising issues about why she was making the recommendation. And
then there was the reconstitution of judicial panels, and then the transfer of justices in some cases. Interestingly, this petition leaked and became public and the subject of intense public debate. Then there was a usurping of rules of court committee, and then judicial manipulation as well. That failed in its entirety because the president and the Council of State determined that there was no prima facie case, and that was done within 17 days, because I calculated when we got word of when the petition had been sent in and when the president, around January 4th, thereabout, issued out that release that no prima facie case had been brought against Madam Gertrude, Chief Justice Gertrude Isaba Torkornoo.
In fact, it was a very controversial petition in that many had raised the issues. It had been sent at the time that the previous government had lost the election. So everyone knew that the government was exiting, and people had raised concerns about why the petition had been sent at that point in time and whether it will be able to be exhausted or dealt with within the life of President Akufo-Addo's presidency, what remained of it. And in the event that it was not concluded, will it be a matter that still remains within the remit of the presidency such that the new administration could deal with it?
Take it over.
All those legal back and forth never came into play because, like you did indicate, just before the exit of President Akufo-Addo from office, he disposed of that petition through his consultation with the Council of State that a prima facie determination had not been made. And so that ended it by way of that. But in terms of the numbers, it does appear that what we've looked at so far, she's the one to have received the most petitions seeking her removal from office. Four so far.
Four. And it looks like of the last three which has come forth, they have managed to cross the threshold which has never been crossed before, in so that a prima facie, essentially, I don't like to use the word prima facie because persons watching might not understand so well, but essentially there is merit and a case to answer in these three petitions which have been taken to the presidency. Hence, the president has decided to set up this committee and to afford the Chief Justice the opportunity proper, in camera, not in the public domain, for her to address these petitions one after the other, and then a determination will be made by this 5-member committee. And again, we remind viewers that whatever decision this 5-member committee reaches, the president doesn't have a say as to what decision is reached. When the committee reaches a decision that the petitions, yes, there was a determination that there was a case to answer, the Chief Justice has answered them and answered them well, and so we've dismissed of these petitions. The president cannot say, relook at the matter, or let's see what can be done in this. Nothing of that sort. He has to heed to whatever decision is arrived at by this 5-member committee.
In fact, so far we've been making a point about the fact that this is historical, but the 146 procedure itself, we've seen it play out a number of times over the last couple of years. The one that comes to mind quickly for everyone is Charlotte Osei, also a 146 procedure. We know that eventually the committee came out with its recommendation and it resulted in her removal. We can now head to the court now. Lord Edu Asari is our legal affairs correspondent. He is stationed at the Supreme Court now. He's joining us right about now. And where Lord is standing, just some few meters away from there, behind the main Supreme Court building, is where the office of the Chief Justice is so far. And we are going to go to Lord shortly, but let Lord hold the line and let's bring in to the conversation Dr. Justice Shemsa. He's the Deputy Attorney General. Doc, thank you so much for joining us this afternoon.
Very much, my brother.
Doc, I want to start off from what transpired today and linking it to an interview that we had with the Attorney General himself that had made the point that, well, as far as he was concerned, no law allowed the president to be restrained from performing a constitutional duty. Is that to say that the office took that view and the president was briefed on that matter by way of advice, which resulted in this consultation going on, even though you are back in court on May 6th?
Yeah, so thank you very much for the question. As my boss indicated last week, when it comes to constitutional function, I think the position of the law has been that no one can prevent a person from performing a constitutionally mandated function. The only circumstance at which the person may be prevented or may be restrained is when a court makes an order for the person to be restrained. As we stand today, there is no such court order which restrains the president from, or the Council of State from continuing with the process which the Constitution mandates them to perform. So I would reiterate the point that my boss made last week, that there's no restraining order on any of the aspects that the president and the Council of State.
I mean, there are those who make the point that by virtue of this action, you have basically rendered the two cases that are seeking to injunct the process, you have rendered those cases moot. And they make reference to other decisions in the past of the court that suggest that you ought to simply hold on and not take any steps that potentially affects the possible outcome that the individual is seeking from the court.
No, so there must be, I think we need to look at two things. There's an application for an injunction, and also there is the substantive case. Okay, what would constitute? I mean, the substantive case
is still on, as far as I understand it, and there's nothing moot about it because the issue that the plaintiff has raised is an issue seeking the court enforcement of a provision. And so that is still be, which is that whether the Chief Justice should be given the petition, should be given a copy of the petition even before it is forwarded to the Council of State, So that issue is still will be there, and I believe it will be a relevant issue for the future in the sense that next time that there is any such petition, we will know whether it could be transmitted to the Council of State before the Chief Justice is given a copy. So far, and I don't know, so far the practice shows that every petition that has gone, to the Council of State, had gone to the Council of State before a reference is made to the Chief Justice involved. Even the previous, petition which the former Attorney General, that Dr. Yabo Adami government pretended over, the record shows that it was forwarded to the Council of State before the Chief Justice was given a copy. So even though it's a strange proposition, we believe that a clarity from the court could be useful. In that case, the issue is not moot in respect of the merit of the case. For the injunction, the injunction is moot, but not because the president's decision, not because of the president's decision. It became moot the moment the Chief Justice got the opportunity and responded. That was when the injunction became moot as far as my understanding of the law is concerned. So if there's any mootness, it wasn't caused by the president going ahead to find a prima facie case or to suspend the Chief Justice. It became moot the moment the Chief Justice was given the opportunity to respond, and he indeed responded to the petition. So that was when it became moot.
On your mootness point, to the extent that in court documents, you argue strenuously that there is no law that requires the president to offer such a hearing. Would you not agree that that, to an extent, leaves the matter still open, that there ought to be some pronouncement on that, even if not in relation to the injunction, even a substantive matter itself?
That is what I said earlier, that there are two aspects. One, where the mootness comes in is when it's about the injunction. That is where the mootness comes in. But in terms of the merit, the substantive cases from the argument we have put before the court, it is not, even though, you see, even though it's moot, the court has heard that in future matters, that can also, so the court can still be here to prevent such a dispute arising in the future. So that's why I said earlier that when it comes to the merit of the case, it is not moot, but as far as the injunction is concerned, it became moot the moment the Chief Justice was given an opportunity to be heard.
And in terms of the considerations that the president undertook in terms of the process to come to the conclusion that, well, he should offer her a hearing, was it strictly based on what you had seen from the records in terms of how President Akufo-Addo handled those petitions that resulted in the decision to extend her hearing, particularly because of the fact that you make the point that no law from your arguments allows such a hearing to be extended to her?
No, you see, when the law says that every child is entitled to, let's say, for example, secondary education, okay? Or let me give another. When the law says that, if a law says that a person should not be kept, when they are arrested, they shouldn't be kept for more than 48 hours before being arraigned before a court. It doesn't mean that you should keep the person, for 48 hours. It means that if you can, even 1 second after arrest, you may take the person there. So the fact that we are arguing that the fact that we are arguing that there's no legal requirement that the CJ should be given a hearing before the document is transmitted, it does not mean that when you give a hearing to the person, you have committed or you have violated the Constitution. It only means that you have expanded or you have given more than the Constitution requires. So it's the same thing as saying that 48 hours, it doesn't mean that you should wait for 48 hours. It means that you should do it within the 48 hours. So that is the point. The fact that we have given, the president has decided to give the Chief Justice a hearing, before transmitting or before the committee speaks, does not mean that the president has done anything wrong. And the two arguments can still go together.
I mean, as a legal academic yourself, I mean, the question that I want to ask is, what do you make of suggestions that it is high time we need an instrument to regulate this particular procedure, given that a lot of it, the inroads have been made by way of judicial pronouncements?
Yeah, true. I mean, an instrument will raise a lot of the doubts and will make certain things clear. So, from where I sit, I think an instrument, a legislative instrument or constitutional instrument to further regulate this position, this process, could be very helpful in the whole. Could be very helpful. Yeah, so I agree with you. You know, the other thing which I think we are dealing with is whether the suspension is necessary under the circumstances. You know, when you look at the Constitution, whether or not to suspend the Chief Justice is a question. It's not it's not automatic that whenever a prima facie case is found by the Council of State and the President, the Chief Justice should be suspended. However, there are other reasons why the Chief Justice may be, suspended. So, for example, we have 3 petitions, right, and they are made up of allegations which we, the public, are not aware of. Now, the question is, if you have 3 petitions, you definitely will need a lot of time to prepare your defense and your explanation. So, I think, playing the role of the head of the judiciary, both administratively and then judicially, is already a lot of work, and meetings are involved, and decisions are taken, and lectures and reading and all. That's a very heavy duty. So to put the Chief Justice in a position where he continue to perform these functions, and at the same time also be defending herself in respect of 3 petitions concurrently, that be probably one of the reasons why the President may want to suspend the Chief Justice, so that he would have sufficient time to prepare and defend himself against allegations. Another reason could also be, and I'm saying could because I'm not privy to what went on in the what informed the decision to suspend, but I'm only giving you some of the possible considerations. It could also be that elements of preventing interference with the inquiry. As you may know, the Chief Justice is the head of the judiciary and is administrative head, and all the Supreme Court judges are, more or less subject to her administrative directives. Now, the question is, you have 2 Supreme Court judges who are on the panel, and you have a lot of administrative matters that may probably come up. So, to give way for a very fair and impartial inquiry, it will also be important to ensure that the head of the institution is not at the same time the one being investigated, to avoid situations where the investigation be tampered or be interfered with. So these are some of the two reasons which may inform the decision to have the Chief Justice suspended pending the investigations.
And finally, it's a question we asked the Minister in charge of Government Communications about who replaces her. We had earlier engaged Martin Kpebu, had agreed on the point that the senior most judge would be acting as a Chief Justice. Is that the understanding from your office for now? We expect Justice Paul Bafoboni, the senior most Supreme Court judge, to be acting as the Chief Justice.
Yes. So, it is true that when the Chief Justice is unable to perform the functions of the office, either by reason of travel, by reason of absence, by reason of suspension, by reason of dismissal, even in the situation of ill health or even demise, the position of the law is very emphatic and clear that the senior of the Supreme Court justices would step into that role. So that is automatically what we expect to happen. And that has nothing, the President has no control over that. He has no role to play in that assignment. And I believe the Supreme Court judges are already aware of this, and I expect that they will take steps to ensure that this replacement is done.
Doc, we'll leave it here for now. Many thanks for joining us this afternoon. That is Dr. Justice Sremsa, is the Deputy Attorney General and Minister for Justice, joining us and sharing the perspective of the Attorney General on this particular matter. Mawina.
Well, we'll go to the courts for you shortly, where my colleague Lord Edwasare is on standby for us. But let's go to a former member of the Council of State, Sam Okujetu, who's joined us as well via the phone lines. We're still picking reactions to this very big story that's come through that the president has suspended the Chief Justice following 3 petitions brought to him which have determined a prima facie case against a 5-member committee has been formed, and the Chief Justice is now expected to mount spirited defenses before this 5-member committee. Mr. Okujeto, would you say, based on the conversations which started from the beginning when these petitions went up until now, crossing this threshold has come to you as a surprise? Mr. Okujeto, I'm asking if everything we've seen playing out in the last hour or so has come to you as a surprise, this suspension of the Chief Justice and the formation of the 5-member committee.
Both as a lawyer and an observer of the political scene for a number of years, I realize that sometimes there are political manipulations which are also clothed in legality, but there is also what must be constitutional provision which must be complied with. And the announcement that has been made, of course, is in compliance with the Constitution.
You say,
yes.
You say manipulations. Is it your suspicion that the process, as we've seen it play out, could have been manipulated to serve a particular purpose?
Well, let's put it this way. We live in a country which is very, very political, and perhaps sometimes it affects or it clouds people's judgment, conduct, action, utterances, and so on and so forth. But when there is a particular provision in the Constitution, I see what has been said or done is actually in compliance with what is in the Constitution.
Let's lean in a bit on your experience when the first petition was taken by Professor Kweku Asare to President Akufo-Addo. You were one of the members of the Council of State who were consulted in that entire process. Considering the position you have now on the argument that this process could be subject to political manipulation, what would you say are the lessons you drew from that process and what can be done going forward from what we've seen play out today?
Well, this is what I'm saying, that constitutional provisions are there, but it does not prevent people from putting political sentiments into it. It does not prevent it from happening. It can happen. And so far as I know, the previous petition that was sent made against the Chief Justice was surprisingly dated 18th December, which I thought was a little odd, that if a government is in office for maybe some 3 weeks or so only, and then somebody sends a petition, it smacks of, something else. But of course, it was dealt with by the Council of State, and the Council of State said they found no merit in the petition, and we recommend that it be dismissed. So that is what happened. But then the question is that when people are bent on someone, then you find out that other people will be writing petitions. And, well, personally, I feel that it's a dangerous thing for any democracy when you begin to, when the public is allowed. Well, sometimes when people say that the public has a right. Yes, the question, of course, is that the public right sometimes is also suspicious in the sense that not everybody understands the judicial system or the way it works.
Right.
Not everybody even understands what goes on in the court. Sometimes even a judgment is given and people accuse the judges of being biased and so because the judgment does not come the way they want it to be. Unfortunately, even sometimes some of my own legal colleagues also make utterances of that nature, which is also quite sad, because we know that when you go to court, you either win or you lose. And also, being a law teacher, I realized many times that the student made that mistake of having a pass mark, and I always try to tell them that in the court there's no pass mark. You either win or you lose. And so when you are a lawyer, you go to court, you have to prepare yourself very well to be in your case, not to depend upon pass mark. So I would say that we are human beings, so we are subject to all the weaknesses that is inherent in the human race, where we have biases, we have prejudices, we have preferences, and we realize that our biases, our preferences, and the rest should prevail, as opposed to what others think. So, well, let's see what the will do.
Right. Where do you think this decision to suspend the Chief Justice leave the country's judiciary? What are the possible repercussions we could see follow through on a decision like this?
Well, the suspension, of course, is also a provision which in the Constitution that the President has the power to suspend the Chief Justice when a committee is set up to investigate, what it is. Of course, the President has the power to reinstate that person. But, of course, I don't see it happening in this case. But you are talking about the repercussion. The repercussion is the fact that we all live in an international community. And so oftentimes we in Ghana sometimes forget that. It's that we are a sovereign country. And I say yes, we are sovereign countries, survivor. And so if you say you are independent and you do something, people feel that somehow you are manipulating the judicial system. They cannot trust your judicial system any longer. No investor, of course, will come and invest money in your country. So there are serious repercussions in some of these matters that I realize many Ghanaians don't understand.
Right.
That even sometimes even our lawmakers, who are supposed to be the epitome of knowledge, they also sometimes don't has repercussions elsewhere. That there are others who are also looking at the system, looking at it, and that is my fear.
Right. Mr. Okudzeto, I appreciate that you could share your thoughts with us this afternoon as we continue to process really what it is that's happened, what happens from here on in. We're expecting the senior most justice at the Supreme Court to take the helm of affairs in handling matters at the judicial service, amongst many other things. I believe we can go to Lord Edwasari right now.
Yes, Lord is stationed at the Supreme Court. Lord Edwasari, our legal affairs correspondent, standing a few meters away from the main Supreme Court building. In fact, those who are familiar with the place, just behind the main Supreme Court building is the Chief Justice's block, the block where the judges have the offices, the Chief Justice also on that block as well. Lord, what is the talk in and around the office space that the Chief Justice has in the last couple of years been serving the Chief Justice?
Right, Blake. So the general talk and, in fact, the atmosphere here is one of sadness, uncertainty, and anxiety. A few of the staff I've been speaking to have indicated that this, they acknowledge, is unprecedented, and so they actually do not know how things will pan out, but they have been speaking very fondly in positive light about Chief Justice Gertrude Torkornoo. They've been saying that she's someone who knows her stuff, and they also talk about the fact that she's come to transform the judiciary, talking about the fact that she introduced and expanded the e-justice system, among other things, initiatives that they are stating that she's brought since she became Chief Justice. They are not too happy about how things are going. The general talk was that, and you bear with me with that, this morning, as early in the morning, we got notifications, social media, a lot of talk about the suspension of the Chief Justice they had seen, and that sort of built up the tension that they have been experiencing now. And so the final statement, which was issued a few hours ago, confirming that the Chief Justice has been suspended, sort of like affirmed the uneasiness that they have been feeling. But all they're saying that they hope that she will come out whole and vindicated because of the fact that as a boss that they've worked with, she's been very positive, and they just had positive words for her. Lord,
I'll have you hold the line for me. We'll come back to you and engage a bit further on the situations, on the issues playing out at the Supreme Court. And the other question we want to find out is whether we know whether she was even at work today. What have we picked about that as well? So we'll come back to you shortly. But Mawina, we have some more reactions coming through.
Yes, let's speak to the president of Imani Africa, Franklin Kujo. He's joined us right now via the phone lines as well. Mr. Franklin Kujo, many thanks for speaking to us. The big question for a lot of people is what happens from here on in. Perceptions and questions about whether or not this impugns the judiciary's long-held belief of being independent of executive power and all of that. Where do you stand in that argument now that we've entered what many are describing as uncharted waters?
Well, good afternoon to you. Well, this wasn't surprising. I think it was already in the works. So I'm not entirely surprised at all. It's the grounds upon which she's being suspended. Anything to go by, some of the things we picked up. I have not seen what the suspension letter said, so unfortunately. But if it is the things we read and saw, that issues around, should I call them procurement or certain infractions regarding travel bursaries and all of that, those are slippery grounds for which you could be suspended, and in any organization, I suspect. So it may sound political, but unfortunately, I think if those issues were really, some of them came up, and it would be difficult for the Chief Justice to have a say in the whole matter. So for me, I'll say yes, it has nothing to do with judicial interfering in judicial independence, not at all. But the way we appoint our Chief Justices here is just political, isn't it? I mean, if it was a case that was like what they do in Kenya, where the persons appointed actually have to go through a whole vetting, live vetting, and then later to be, everybody gets to know how he or she performed before the president appoints the person. Then would have had little worry when people are suggesting that, oh, okay, well, there's political interference. But in this case, the Chief Justice appointed by the president anyway, right? Is that not the case? So for me, at the end of the day, look, it is what it is. We need to start looking at the processes to which we appoint our justices, or even nominate justice to the Supreme Court. That has to change, I think. Otherwise, we'll keep crying foul. But if there's only evidence to go by all that have been said, well, I'm sorry, it will be difficult for her. I mean, I know I've known Torkornoo quite well. I mean, I worked with her when she was a supervising high court judge. We worked together, fast-tracking the doing business work. I was a representative of CSO representative. We did some research together, and she was so super efficient. I looked at if once we become Supreme Court Chief Justice, then the expectations are so much that if you don't take care, you may fall in the trap of being accused of being partisan. Don't forget that her own predecessor was just too overly partisan. I've never seen the Chief Justice so biased and partisan as him. She was a significant. That's the name, right? Yeah, extremely partisan guy. But anyway, he played his cards well. It looks as if Torkornoo overplayed a hand in some of these issues, especially some of the very political issues. And unfortunately, that landed where she's got into. So when the politician is looking for you, they'll find everything and any rule in the book to go after you. I mean, that's how politics says. So if they're looking for you, they'll definitely look for you. I mean, it's natural. And so for me, once I saw those issues around procurement, rather abuses of travel allowance and bursaries, I knew the game was up. It's very difficult. Unfortunately, she had fewer friends in the civil society. Some of us initially were not happy about some of the utterances, but we said, okay, well, look, it's so difficult to remove a Chief Justice. I mean, I think it's one of the things you don't want to do in a country where democracy is supposed to have been rooted, at least in the last generation, for the last number of decades, right? But then when it becomes very clear that, look, the infractions are difficult to support, then it becomes very difficult for some of us to come out and say, okay, well, look, don't crucify her. But then some people start questioning our own independent thought, independent thinking, right? Because if we want to we're happy about Charlotte's removal of a very minor procurement infractions, you definitely cannot go over this. You understand? So for me, it's sad. But well,
We haven't seen portions of these petitions which reference travel allowance and the likes, which you're making reference to. But I want to just lean into the argument of the perception of bias. We've seen Afrobarometer reports, and then the former National Security Minister, amongst many other things, make comment in relation to how the perception of bias against the country's judiciary going forward. Does this process which we're seeing begin to cure this perception of bias to start off with, even before we go into the argument of what is happening to the country's democracy, when we saw a constitutionally mandated individual like Charlotte Osei removed? Now it looks like processes are underway to have the Chief Justice removed as well.
Unfortunately, bias has become one of our should I call it our lunch in this country when it comes to political vindictiveness. And so for me, bias has been too elevated. I would rather suggest that, look, we look at the specific incidents of this biases that we are talking about. I mean, I was mortified, really, and a bit worried that Judge Chiketa was making so much sense that he couldn't be scoring 7-0 all the time during the election petition. I was really mortified. Even if you are the most dumbest of person, at least on 1 or 2 points he could win. What was all of that? I was shocked. I'm not a lawyer, but I was not stupid. I'm not stupid. So I could tell the difference between reason and common sense and law. And on the common sense level, I said, this one cannot win just one of the seven the unanimous decisions. It was harrowing. It was quite. I was scandalized. Then came how they were defending the electoral commissioner. I was so sad. I mean, to the thing that the electoral commissioner's behavior actually led to my own son being denied for 4 years, and the Supreme Court played their hand in our people being denied disenfranchised for 4 years. They never wanted to hear the case. Could you believe the Supreme Court, between Justice Enim and I suspect Torkornoo as well, actually played their hand in so much devious ways to ensure that our dockets were getting missing? Couldn't believe it. That this was whatever I record this here, it's like a movie. Look, so it's very difficult for someone like me not to say that they were biasing one way or the other. I mean, I don't want to bring my issues into the fray, but I could imagine that if this had happened to any other constituency, I wouldn't think the Supreme Court would have ruled otherwise. They would have rather done what they did. I think when Apenyo took the matter. I remember the last.
Yes, the vacant seat saga involving the speaker.
Exactly. And I heard the Chief Justice say that, some people cannot be without constraints, so how you want to deny them? And I said, holy loud. Those people sat back, watched us squirm, including the Attorney General, who together they were playing us like kids in court, almost mocking us. For 4 good years, the Chief Justice and Attorney General were in cahoots. Not this one, by the way. They call you. That call you right. Something like that.
Let's talk.
Very high-handed behavior. It's a franchise just like that. And you see, so when you come and see what has happened to those constituents that were supposed not to have MPs, I think just before the last election. And I think that it says that, these people cannot be without representation for just about a few weeks. And then I ask myself, where is the justice? That's what I call in law legal plunder. You can use the law in one to do other things. So, I'm sorry, bias is what we eat in this country. Well, until it happens to you, you probably call it something else.
Let's talk quickly what happens from here on in. We're seeing the Constitutional Review Committee do some work. The general consensus amongst almost everybody we've spoken to is that something needs to be done. We need to have a relook how the Chief Justice is appointed, amongst many other things. That should come up strongly in all of the work that they are doing going forward, shouldn't it?
Of course, it should. I mean, I know my good friend, Prof. SKP, I'm sure he knows the Kenya situation. We'll probably be talking about it. I think we should adopt that approach, that route. Because that route makes it very easy, very difficult for politicians to interfere, or even make it difficult for the justices themselves to be biased. They wouldn't even be at all. You understand? So that process is rather better than what we have here right now. I mean, look at Nanato. Talk the courts with so many people, high courts, court of appeals. I mean, what's that kind of? I mean, that type of thing it doesn't endanger that group at all. So for me, I think we should look at it again, and this is a perfect opportunity to change that. I hope we get to do it.
Right. I appreciate that you could speak to us. That's Franklin Cudjoe, is the founding president of Imani Africa, speaking to us as well on perception of bias and really what now is becoming a fast clarion call for possible review as to how, as a country, the appointments to the Supreme Court and then the Chief Justice as well is done as the statute books proclaim. I
mean, that's an issue that has always come up quite strongly, and we know that the Constitutional Review Commission, the committee that has been put up, they are currently undertaking their work, and they are taking various feedback from various interest groups. We know that one aspect of their work that they are focusing on is the appointment procedure, particularly for independent state agencies and various arms of government. We do not know what their recommendations would be by way of what the outcome should be, but we know that the courts have had cause to comment on the appointment of process of judges directly, and the court has made a point that the process is a consultative one. It is such that the president, if he's required to consult, he must consult. Where it's a list, he must act within the list and not go out of it. This time around, when even in the times past, when questions were raised about the competency of individuals, the court said that, look, the appointing authority is the one that takes the decision and determines whether the person is competent or not. In your conversation with Mr. Cudjoe, he makes the point about the perception question that you put to him. There's an interesting poll that was conducted by Global Info Analytics, and it centered on the question to people on what do they make of the petition to remove the Chief Justice, whether they support it or not. And Mawena, this is an interesting poll because the people do not know the content of the petition.
Right.
And there are those who have criticized it to say that that makes it problematic. There are those who have, on the other hand, said that that in actual sense should give us a sense of how the people feel about the justice administration system. Because even without knowing the content, how they are giving feedback should tell us something about that. And that is what we are going to walk through right about this point in time. So the question was, do you support the attempt to remove the Chief Justice? Those who supported formed 52% of those sampled. That's the majority. In terms of those who were neutral on the matter, 18%. Then those who opposed the removal, 20%. And those who did not have an opinion, they were 10%. I'm going to go 2 steps forward to show you another graph on this particular point. And it's a question about the party affiliation of those who had provided
that response
that we have brought to
52%.
Now, in terms of the affiliation, we see over there those
the majority of them
belonging to
the governing National Democratic Congress.
Then you see over here those on the other side. In terms of the distribution, this is how it looks so far. And so within the MPP base, just 16%
who were in favor of
the removal. You compare that or contrast it with that of the NDC, you see it being 83%. Then you see those who oppose on the side of the MPP are 46%, whereas if you go to the other side, those who oppose it on the part of the NDC, they are just 3% of that. Yeah. And so if you contrast these two, whereas one, in terms of the outcome, will say that, well, they don't know the content, but they have challenges with the justice administration. On the other hand, we'll say that, well, this outcome tells you that potentially it is the sentiment of the governing National Democratic Congress, particularly because we know that the party had in times past had cause to complain. In fact, the president himself, in the times past, had reservations about the judiciary and said that it was necessary for reforms to undertaken to assure the people of the changes and in terms of what the judiciary will be able to do.
That famous statement that the president made about balancing out the judiciary and the composition of the bench was one that didn't quite sit well with a lot of people, persons associated with the now opposition NPP as well. And so it's not something that's
record a conversation about the regional tribunals as well.
Absolutely. And so all of that and more, you're bringing about an interesting aspect of the conversation, which we'll get into, as to why perhaps we're seeing what we're seeing and why the Chief Justice is that important in the scheme of things with respect to justice administration as well. You're done with this?
Just in terms of the regional breakdown. So these are the high numbers from the regions. In which regions do you have a lot of people supporting the removal or that is taking place? And you see the Western North region, interestingly. Then there's also the Volta region. Then Greater Accra following suit, and finally being the Ashanti region are just around 37%.
And based on the 2024 election results, all of these regions went in favor of the NDC, but the Ashanti region, which the NDC improved their numbers there quite interestingly. And that's just by way of caveat. Again, feeding into what we saw here, that a lot of the NDC supporters are in favor. In
terms of those who participated in the survey, who identified themselves as being affiliated
to the
NDC, took the view that they support the petition for her removal from office. Absolutely.
And again, there are reactions have been coming through quickly following the news that we've been bringing to you here. A number of you have been reacting to the development as well. I just want to run viewers through again some few of these comments. Big thumbs up for suspending the Chief Justice and setting up that committee. Your committee to fairness is, or I think your commitment rather to fairness is awesome. Then this one says, Ish, Ghana, just 4 months of your era, you sacked IGP, cement price 130 cedis. Galam says even worse than what I was expecting. Suspended Chief Justice. Ghanaians voted for you for change, not for this, Mr. President. Divergent opinions. Next time when she gets the opportunity to serve Ghana, she won't be political. That's another of the opinions. Truth says, excellent job, great news for the day. Get the job done. Let's not repeat Atta Mills's mistakes when he left these guys off the hook. In the end, Ghanaians paid dearly for it. If we repeat the same mistakes again and these people return to power, Ghana will be wiped out. The captain of the unanimous FC is finally paving way for freedom and justice, probity and accountability to reign in Ghana. How can you say that a birth certificate is not a proof of citizenship in Ghana? She served her political party well, and amongst many other things. Well, this one a bit harsh. You should go and become women's organizer. Okay, let me try and skip this one. Yeah, now it's left with the, again, persons already alluding to where next the course of action should take in relation to this. But the final comment says, now let the work begin. The real action is about to start. The NDC should go with the oral and that alone. Ghanaians will be okay with JM and the NDC. And it brings about an interesting conversation, one that I believe is important to have. Why, and I'm going to lean that argument from what we're seeing here about oral and the perception of bias which has played out from the perspective of the NDC and then the judiciary as well. The NDC campaigns strongly on oral, Operation Recover All Loot, where people have been baying for blood, literally, not in literal sense, but are seeking to see to it that persons who squandered funds under the previous administration are seen to be brought to book and answer questions. The NDC has promised, amongst many other things, that they are going to see to a return of public tribunals. A big question based on, it's not a question actually, what is the constitutional provision in relation to the public tribunals making a return to our legal jurisprudence? That authority rests with one individual. And who's
the Chief Justice? In fact, during the conversation in Parliament, when the Attorney General had made a point that they had promised to do that, you recall during his vetting, the question was asked that the way the provision is couched is such that the activation ought to be done by the Chief Justice. And already people had made the point that, look, the tribunals do not evoke good memories. They make the point that if you go into our history, they were the places where the military juntas went to exact justice in a manner that was a loud response to what the crowd were asking for them to provide. But they didn't necessarily ensure due process where the tenets of rule of law adhered to. All those were questions that people were asking. In fact, you recall the Attorney General, when he did that major news conference in which he spoke about the former director of the National Signals Bureau, said that, look, this was just the starting point. The prosecutions were going to start. The prosecutions were going to start in April. We're already in April. We've gone past mid of April. People are already asking questions about when is are the cases going to court? And there are those who say that, well, maybe what is playing out now, they want to see that matter settle before the matter goes over to the court. And those are all suspicions that are taking place. And so it's no surprise that that particular comment that came up, the point was being made about the fact that, look, this may potentially be setting the stage for the Operation Recover or Loot to take place. But at this point in time, it's still early days yet because we are at the onset of the process. The Chief Justice is going to question the evidence that has been put up against her. She's going to have her lawyers present. She's going to cross-examine the individuals who have filed this petition. The committee would have to come to a conclusion as to whether she should be removed from office or not. And we have also indicated through our interactions with the various analysts and experts that the president could even, in between the period, decide to revoke the suspension. You say suspend the suspension.
Yes.
Just to make it easy for all of us. But all those are issues that we are gonna discuss in much detail as and when it comes up. But there's another story that we have to tell with regards to what this means for the Supreme Court. And we've already touched on it briefly about the fact that, look, we are saying that as it stands now, the expectation is that His Lordship Justice Paul Bafuboni, who is currently the senior-most Supreme Court judge, will be taking over as the acting Chief Justice. And for those of you who are wondering, it's a lot of responsibility on him. So if a case is filed today, the paneling ought to be done by the Chief Justice. For which reason, if she's suspended, someone ought to step into that role to ensure that the justice administration follows through. As the administrative head too, they are the decisions that she takes on a daily basis. So he's stepping into that shoes, and he is age 68. Very, very senior Supreme Court judge. He has been at the Supreme Court since 2008.
That's almost what? That's 17 years.
And he was appointed to the Supreme Court by President John Agyekum Kufuor. So imagine, a judge who has been there from Kufuor through to Mills, to Mahama 1, to Akufo-Addo 1 and 2, now to Mahama 2, and he's still at the Supreme Court.
Then there's His Lordship Justice Gabriel Puaman, who we've mentioned already, is chairing this 5-member committee as well. Just a bit more on him.
Yes, he is also a very experienced Supreme Court judge, joined the Supreme Court in 2015 there, and he's aged 64. And like we had indicated to our viewers that he is leading the committee, the 5-member committee that has been set up to look into the petition relative to the Chief Justice and whether or not he should be removed from office. And I did indicate earlier that very interesting judge by way of his judgments. He explains the principles in details and a lot of decisions that have come by way of that particular.
There was an interesting development in relation to him just some weeks ago, and that as well is of importance to mention. Someone had taken a petition against Justice Gabriel Puaman. That petition was supposed to be taken, or in
fact, a petition was sent to the presidency. It's a petition by a former clerk. The clerk worked with him at a law firm when he was in private practice.
Right.
He petitioned the president asking for the removal of Justice Gabriel Puaman. The petition was sent to the presidency, and that petition, in a couple of weeks' time, was withdrawn by this individual who had filed the petition. And so that meant that there was no process ongoing against him. But for those who be reading things into, they will say that, well, that's the story of life. A few weeks ago, he was a subject of a petition himself. Today, just like the Chief Justice today, he's the one chairing the committee that will come out with his recommendation to determine whether the Chief Justice remains in office or not. And he's 64. And just for purpose of education, we are keeping the ages there because their retirement age is 70. So that is by way of...
everybody else goes at 60, justices of the Supreme Court, 70.
Yes.
Let's move to Her Ladyship Justice Everil Lovelace Johnson.
Yes, another senior Supreme Court judge, he's 63, appointed to the Supreme Court by President Akufo-Addo.
So we're moving in the order of seniority.
Order of seniority, yes. Exactly. So she's the next senior most, aside from His Lordship Justice Paul Bafuboni, now the acting Chief Justice, and His Lordship Justice Gabriel Puaman. She comes in next. Those of you who don't remember her, just quite recently, the 2 cases, the anti-LGBT cases, the 2 cases that challenged the law that was passed by Parliament. She was the one who presided over the main panel that delivered the judgments in the 2 matters. And the final one will be His Lordship Justice Isufu Omoro Tanko Amadu. He participated in the vacancies judgment. He actually dissented on it. He wrote a very lengthy opinion disagreeing with the conclusion of the Supreme Court that were arrived at, that what had been done by the Speaker of Parliament in Parliament by declaring those seats vacant were contrary to law. He disagreed with that and felt that the case ought not to come to the Supreme Court for the Supreme Court to deal with.
Professor Henrietta Joy Abena Nyakomen Sabonsu as well, also a member of the Supreme Court, an astute academic.
Yes, criminal law expert as well. She also authored a lot of articles in the area of family law. She is actually the president of the panel that is hearing the cases that have been filed against the removal process of the Chief Justice,
the injunction
and
processes
the
and then
Asante one. She's the one handling that particular
His
one.
Lordship Justice Emmanuel Yoni Kolendi, another name that pops up quite strongly, has come up in a lot of conversations as well. Walk us through him just briefly.
In fact, during the appointment process for the current Chief Justice, his name came up as a possible person to be appointed. He's age 61. The most recent decision that he's rendered that got many people talking, and it's now an important constitutional law case, the case of Justice Abdullahi versus the Attorney General. The conversation surrounding the e-levy approval, whether the Deputy Speaker presiding can vote and all of that. He authored the lead opinion in that particular case, appointed to the Supreme Court by President Akufo-Addo. He is there as well. Then the next is His Lordship Justice Samuel Kwame Adibu Esiedu. We've tagged on him already.
And so perhaps we might, but just by way of a reminder to those watching and listening on 3FM, he is the second Justice of the Supreme Court on that 5-member committee who are expected to determine the fate of the Chief Justice. His Lordship Justice George Kingsley Kumsin as well, 62 years of age.
Yes, he used to be at the Court of Appeal, is now at the Supreme Court as well. Most of you may remember him for the Jura Committee report. You remember the disturbance at the Jura, the committee that was set up. He led that particular process as well. And so he is also at the Supreme Court. Then the others are Justice Yao Geu. We've touched on him briefly in some of our discussions. Justice Henry Kofi also joined the Supreme Court from the Court of Appeal, appointed by President Akufo-Addo. For a while now, he was leading the Association of Magistrates and Judges. Then there is His Lordship Justice Yao Daku Asari and His Lordship Richard Ejie Frimpong. Both were appointed by, President Akufo-Addo as well.
Let's return quickly to His Lordship Justice Paul Bafo-Boni, the senior most at the bar, and the expectation is that he will be acting in the stead of the Chief Justice, who is now suspended. What we're hearing is that there's been some word that's been communicated from the president. We're seeking to have that confirmed quickly, that indeed, as we've been discussing, as Counsel Martin Pebu as well proceeded to provide details of, he's a senior most, is expected to take assumption of the entire judicial process, amongst many other things. And so he will be acting in the stead of the Chief Justice. And so that's just by way of news that's coming through as well, even as we try and get back to the presidency with fresh details. And a bit more on him, Justice of the Supreme Court of Ghana since 2008.
We've touched on that. Currently the most senior at the Supreme Court of Ghana. And just by way of some of his judicial matters that he's dealt with, I mean, he was part of the very first election petition that took place, the 2012, the one after the 2012-2013 election petition.
Had the country locked down for almost a year.
He was one of 5 judges who took the view that the petition does not raise issues that should result in a cancellation of the results as had been announced by the Electoral Commission chairperson. And he, like we did indicate, was appointed to the Supreme Court by President John Ajikun Kufuor and has been at the Supreme Court since that time.
And so that's the latest. Let's try and go back right now to Komla Kluche, who is our presidential affairs correspondent. On that word we're picking, that there's been communication from the presidency to Justice Paul Bafo-Boni that he is acting as what is the
acting Chief Justice.
Acting Chief Justice. Komla, talk to us about it. When did this word go through? Can we confirm it? Has there been a response from him as well? Well, Komla, we cannot hear you just as yet, but perhaps we'll try and get a bit more on Justice Paul Bafo-Boni. And you were mentioning the fact that he sat on that 2012 election.
He was part of the panel, the 9-member panel that dealt with that particular petition. I mean, it was a very serious case. The first time that an election petition had gotten to that level of the justices having a full hearing. You had individuals going to the witness box. That particular case, just for context, was filed by Nana Danko Akufo-Addo, Jacob Otanko Bechebilamte, Jake Otanko Bechebilamte, and Dr. Mahmoud Bawumia. Those were the 3 petitioners who filed the case against John Dramani Mahama, who had been declared as winner of that particular election. We know that subsequently, the National Democratic Congress did apply to be allowed to join this particular case. And that is how come you had Chachuchi Kata coming in as counsel for the National Democratic Congress, whereas Tony Later representing John Mahama in court in that particular process. And I mean, Nana Danko Akufo-Addo simply asked the court to annul a number of votes issues about pink sheets that had not been signed by presiding officers, because the constitutional provision says that the presiding officer shall sign the pink sheets. The Supreme Court disagreed with him by way of the majority opinion. Justice Paul Bafuboni was one of the 5 judges who ruled, making a majority opinion that ensured that the election results that had been announced by the Electoral Commission was what was sustained.
And that led to quite some reforms in our electoral process as well. That 2012 election petition, it resulted in quite a number of reforms which have improved our elections subsequently.
Even in terms of the petition process itself. I mean, this was a petition that lasted
almost 8 months, 8 to 9 months.
Almost 8 to 9 months. I mean,
which many argued rendered that first year of John Mahama a bit difficult, because there was a question of whether or not investors could come in when there's an election petition looming over your head. You could be declared an illegitimate president, and that what becomes of all of your plans and all of that. And so that resulted in reforms which now saw that all of these petitions have to be dealt with maximum, 90 days
yes.
for presidential election petition.
I mean, we are still yet to make inroads in terms of the parliamentary petition.
Yes.
And that is also another area that we may have a conversation on eventually. But for the presidential petition, it made reforms. And when the second election petition went to the Supreme Court, he was not on this panel, though. But that was the petition that was filed by John Dramani Mahama following the 2020 election against Nana Dankwa Akufo and the Electoral Commission. And we know that in that instance also the Supreme Court affirmed the electoral results that had been announced as well. But that petition went smoothly and in a much faster manner than the first one, which Justice Paul Bafuboni participated in as one of 9 judges who heard that particular matter.
Let's try and see if Komla Kluche has rejoined us, and we'll get the indication that Komla also joined us just as yet. But one other thing, perhaps we should be able to walk viewers through.
I wanted to show you something interesting. When we were looking at the senior most at the courts.
Right.
You see what is happening with these 2 here?
Yes.
Yeah.
The senior most becomes acting, then the one who follows is the one who's chairing that particular committee, which determines the fate of the Chief Justice. I mean, there's been opinions littered across social media in the process of when these petitions were sent, and many argued that in some of the very controversial matters where we were requiring the expertise of some of these senior-most justices, we were not seeing them on the panel of Supreme Court justices. I don't know where you stand on that argument, but it was one thing that came up from time to time, why we were not seeing the experience of His Lordship Paul Bafuboni and then Gabriel Puaman as well. But again, very interesting how this is playing out in relation to what we're seeing right now.
In fact, during the discussions around that, many have even made a point. I remember on a social media platform, a conversation, some were even making a point that they were surprised to find out that Justice Paul Bafuboni was still at the Supreme Court. Yes, he was still at the Supreme Court and he has been there all throughout this period. But this is a story that very fast developing. I mean, right from when we came on air, the news that we brought to our viewers did indicate the big one from the presidency, with the president indicating that the consultation with the Council of State has come to the conclusion that at first instance, they think the petition discloses matters that merit an investigation. And so the breaking news that we brought was that the Chief Justice had been suspended. Then the other part of the news had to do with a committee that had been set up to look into this particular matter. In between that, we're having a discussion about, well, automatically the senior most takes over. We've had confirmation in between now that he's been formally notified, even though it's already allowed by the process. The Minister of Government Communications said that, well, the judiciary was going to decide. But the Deputy Attorney General told us that they expect him to take over because he's the senior most at the Supreme Court. And that is how this story has been developing at this point in time. On May 6th, there will be a case in court.
Which is a big one in relation to whether or not the process which was seen proceed. Now we're entering uncharted waters. Again, one of such individuals in this list, Kwame Adibu-Esiedu, is seated on that panel, which is to determine whether or not the processes which is currently ongoing should be halted. And I mean, we've had legal opinions which say that once a Chief Justice responded to the President's letter, then that injunction application became moot. But then again, what happens to the substantive is another thing that we'll seek to provide answers. So we hope we've been able to make meaning of a lot of the things that's just come through over the last 2 hours to you. Joseph has mentioned or reiterated really what's happened thus far. There'll be a lot more for you if you stay with us here on TV3, on 3news.com. You'll find as well a lot more news in relation to this. But let's just hear from the Chief Justice, if we can. But I am Mawena Egbert, and I've been doing this with my colleague
Joseph Akable.
Let's hear from the CJ as we leave the studio.
Juror who has been empaneled fails to attend court on a day, it will be understood that no work was done, thereby affecting the ability to pay allowances for the day. In this regard, 4 men are respectfully requested